Good morning, everyone, and thank you for joining us today. I hope everyone had a lovely Easter break. My name is Richard Barnwell, and I'm a partner within BDO's Financial Services Advisory Practice. I work with clients across the FS sector on a range of assignments, including within internal audit, regulatory advisory, and I'm also a skilled person under FSMA. One of my main focuses is on governance, risk management, and conduct across the FS sector. So as you can imagine, it's been a busy few weeks and continues to look busy for the foreseeable. I'm also joined by my colleague, Shrenik Parekh. Shrenik is a senior manager who both specialises in governance, risk management, and SMCR. The first thing I wanted to say is that from all at BDO, we hope you're well and adjusting to these new norms. Over the past few weeks, we've been supporting our clients respond to the crisis, and through this, together with ongoing conversations with the FCA, PRA and trade bodies, we've gained insight that we're very keen to share with you. Obviously, every firm will have different priorities and challenges. However, it is clear that effective governance and clear accountability for decision-making is central to and fundamentally important for all businesses during this time, including those within the financial services sector. There are also significant implications for board members and SMS function holders who need to be decisive in protecting their people and organisations throughout this current phase of the crisis to the next one, and indeed the longer term. The audience for this webinar consists of clients across the FS sector, and therefore we've made the content largely sector agnostic. It follows on from our webinar last week, which I know a number of you also attended. And for those of you that didn't, the webinar was recorded and we will provide a link in our follow-up email to this session. As many of you may be aware, and indeed we touched on this last week, the PRA and FCA released a joint statement on the 3rd of April reminding firms of their obligations under the Senior Managers and Certification regime. The FCA also issued a statement on the same day, setting out their expectations for the solo regulated community. This webinar is designed to highlight some of the key issues for both solo and dual regulated firms and how the regulator's updated guidance may affect you in practice, sharing insights with you from our work with clients across the FS sector. To this end, I'm planning to focus on 4 key areas. The first is around changes to the senior manager responsibilities and notifications to the regulator. The second area is on the 12-week rule and temporary arrangements. We'll also speak around furloughing senior management functions and also something that I know a number of you are interested in, this sort of topic of demonstrating and evidencing reasonable steps during these difficult times. We expect our material to last for about 30 minutes today, which should leave us with plenty of time for Q&A at the end. Before I hand over to Shrenik, there's just a few housekeeping points that I wanted to cover off. So today's webinar is going to be recorded, and we will circulate the slides later together with a link to the recording. Your lines will be automatically muted throughout the webinar. So please submit your questions to the panel as we go along using the Q&A box on the bottom right-hand side. When you do that, please ensure that you send the questions to all panelists, and then we will try to cover these at the end of the webinar. If you're having any problems with the sound or anything else, I suggest that you also just type something in the Q&A box because we can all see that, and then hopefully someone can help you if indeed you're in trouble. So without further ado, I am going to hand over to Shrenik, who's going to talk about some of the publicised changes that have come out of the regulator.
Thank you, Richard, and good morning, everyone. The speed and breadth of the unfolding COVID-19 crisis is putting nearly every facet of business to the test. As Richard mentioned, there are significant implications for boards and senior managers under senior managers and certification regime who need to be decisive in protecting their people and organizations throughout this current phase of the crisis, not just now, but also in the longer term. The regulator, both the PRA and FCA, are completely alive to this point and recognize there may be changes to senior management function holders' responsibilities during this abnormal time. The regulators have indicated that they want to take a pragmatic approach to SMCR compliance, minimizing the burden for firms and relaxing some of the SMCR requirements. However, it is important that this is not confused with a relaxation of the principle of individual accountability and robust governance arrangements. Many firms have inquired whether the Senior Management Function 24, Chief Operations, should take responsibility for the firm's response to coronavirus. While compliance with regulatory requirements in relation to business continuity, information security, and outsourcing would naturally sit with the SMF24, several aspects of firms' responses to coronavirus, for example, managing liquidity, may naturally sit with other SMF holders. The statements released by the regulator outline that firms are not required to have a single senior manager responsible for the COVID-19 response. Clearly, it would be incredibly challenging for a senior manager to take full responsibility and accountability for this. However, the regulator does recognize that current circumstances may mean changes to the responsibilities of many senior management function holders. Dual-regulated firms will need to revise, update, and resubmit statement of responsibilities for its senior managers. While there is no fixed statutory deadline for firms to resubmit the statement of responsibilities at this stage, and this is something that the regulator is reviewing, encourage firms to review its responsibilities for their SMF holders have changed in light of the crisis, and resubmit impacted statement of responsibilities as soon as practical. From our perspective, this tends to work best with boards engaged and leading the process with input from HR and compliance as necessary. The FCA does not expect solo regulated firms to resubmit their statement of responsibilities for its senior managers. If the changes made to cover multiple sicknesses or if changes in responsibilities in direct response to the pandemic are temporary and will not change permanently. However, it is important to note.
Hello, everyone. Sorry about that. We seem to be having some issues with Shrenik's sound, so I'm just going to pick up from where he was. So we're talking about the 12-week rule. So, of course, it's expected that there will be scenarios where firms need to make temporary arrangements to cover absences, perhaps due to sicknesses or for furloughed staff. Many of you will be aware of the 12-week rule, which allows an individual to cover for senior managers without being approved where the absence is temporary or reasonably unforeseen. The regulator understands the concerns that many firms have in respect of compliance with the SMCR requirements, including the 12-week rule, and does intend to offer flexibility where possible. So just focusing on dual-regulated firms, specifically for dual-regulated firms, the PRA and FCA are currently gathering evidence on whether the 12-week rule is likely to give dual-regulated firms enough flexibility to deal with temporary absences of an SMF holder as a result of COVID-19. If the FCA and PRA conclude that the 12-week rule is insufficient to allow firms to respond to temporary SMF absences linked to coronavirus, they will consider additional measures. Firms should still allocate to the most senior person responsible for that activity or area who has sufficient authority and an appropriate level of knowledge and competence to carry out the responsibility properly. The covering manager will require access to the governance forums they need to exercise their responsibilities. Changes of this nature should be recorded in other documents such as responsibilities maps and role profiles to ensure that firms have a running record of temporary allocations to unapproved individuals. For solo regulated firms, it is also worth noting that regulators are relaxing the 12-week rule for temporary arrangements for solo regulated firms, extending this to 36 weeks for firms that notify the FCA they would like this extension. There is an expectation that firms clearly document these responsibilities, however temporary, including on relevant statements of responsibilities and responsibilities maps if applicable. Usually, prescribed responsibilities can only be allocated to another approved senior manager under this rule. All firms, both dual regulated and solo regulated, are expected to still do this if possible. Under the modification, firms will also be able to allocate the prescribed responsibilities of the absent senior manager to an individual who is standing in for that senior manager, even if they are not approved. Our view is that all firms should consider the temporary arrangements that may need to be implemented in light and in response to the coronavirus, and ensure that all documentation is updated to reflect this as soon as possible. Firms should update the PRA and or FCA supervisors by telephone or email in relation to these temporary allocations. In particular, for individuals who are not typically classified as senior managers under SMCR and do not require regulatory approval, however have taken on temporary arrangements, we would recommend that these individuals have undertaken adequate training in respect of the SM conduct rules, the definition of reasonable steps, and examples of potential conduct breaches as any senior manager would be expected. In addition, we would recommend the unapproved senior managers liaise with the absent senior manager, if possible, to ensure an adequate handover takes place in consultation with HR and with compliance. So I'm now also going to just talk a little bit about furloughing. So it is possible that some firms may have to make some tough decisions around the furloughing of senior management during this time. The PRA and FCA appreciate this may be the case. They do, however, encourage all firms to carefully consider the risks and unintended consequences of furloughing non-mandatory SMF holders. Firms should update their supervisors of any furloughing of one or more SMFs by email or telephone. So just focusing on dual regulated firms for a moment. So for dual regulated firms, the PRA and FCA's latest statement provides prescriptive guidance on combinations of SMS that dual regulated firms must perform at all times, irrespective of the potential impact of the coronavirus. Essentially, this means that dual regulated firms must have individuals performing one of the following combinations of SMS at all times as a minimum. And you'll note that a few of these are sector specific. So CEO, SMF1, CFO, SMF2, and chair of the governing body, SMF9. A head of overseas branch, SMF19, if relevant to your firm. A small insurer senior management function, SMF25, for small non-Solvency II insurers. And a head of small runoff firms, SMF26, for small runoff insurers. The regulator has explicitly stated that individuals performing SMF16, which is the compliance oversight one, and SMF17, the MLRO, and the limited scope function SMF29 should only be furloughed as a measure of absolute last resort. As mentioned before, firms can use the 12-week rule to arrange cover for individuals performing a mandatory role if an SMF becomes absent. Other SMS are not mandatory under PRA and FCA rules, so firms do have greater flexibility than was previously available to them. However, the regulator has stressed that firms think carefully about the risks and unintended consequences of furloughing non-mandatory SMFs, and in particular, those responsible for business continuity, cybersecurity, or outsourcing. So this potentially could cover someone like the SMF24, the Chief of Operations. For solo regulated firms, by contrast, the FCA has not prescribed any specific requirements for mandatory SMS, with the exception of individuals which may be considered key workers, such as the SMF1, Chief Executive. Unless a furloughed SMF is permanently leaving their post, the individual will retain their regulatory approval during their absence and will not need to be reapproved unless they are permanently leaving their role, in which case, of course, a Form C will need to be submitted for these individuals. However, it is important that firms ensure that furloughed SMS remain fit and proper on their return. If a firm is subject to the overall responsibility rule in SIS 26, the responsibilities of the furloughed senior manager must be allocated to another senior manager. If the firm is relying on the 12-week rule, the replacement does not need to be a senior manager. So just moving on now to demonstrating and evidencing reasonable steps. So many firms have questioned the impact that coronavirus has on accountability for decision making and how individuals can demonstrate and evidence that they are taking reasonable steps during this uncertain time, which is absolutely a fair question. And as I mentioned earlier, we did touch on this very briefly in last week's webinar. However, from the regulator's perspective, the underlying principle of individual accountability for decision making has not changed. The onus is on the firm to adapt to the different environment we live in now under the SMCR, and naturally, senior managers are very much part of that. Both the PRA and FCA have stressed the importance of continued strong governance through this crisis. SMS holders are going to have to make a number of tough and key decisions in the coming months, in some cases sooner than they might usually do. It's important that SMS holders clearly and comprehensively document rationale for decisions and actions taken. Given the shock this crisis has presented to financial markets and the potential long-term implications, it has never been more important to maintain clear and complete audit trails for all key decisions that are made. Ultimately, firms' records need to be kept in a way that is readily available and presentable to the regulators on demand. Many boards and management teams will not be meeting during this time, or alternatively will be meeting via video conference. There is a challenge in that meeting minutes may not necessarily reflect robust challenge. The input each individual has into collective decision making is therefore very important, and it's important that each SMS holder takes personal accountability for the responsibilities that they are discharging. Given the fast-moving nature of the crisis, regular virtual meetings of senior management should be scheduled to identify new developments, understand regulatory expectations and the impact of policy decisions on the firm's business, and to set the firm's overall strategy on responding. Records should be kept of key decisions taken at the meetings to demonstrate how the management team has responded and what key issues have been considered. We also suggest maintaining a personal record of CPD and training webinars during this time, such as this one that you're attending today. One area which has definitely become more challenging in this environment for senior managers is maintaining oversight of employees and the systems they are using. Consequently, there is a heightened risk of market misconduct and cybersecurity breaches. Reasonable steps in this context may mean implementing changes to monitoring systems, communication from management teams about managing conduct risks, and ensuring that these are managed within the organisation's risk appetite. Appropriately adapting and updating existing MI and information flows is also likely to be important. In addition to these specific considerations under the SMCR, boards and SMS holders should carefully consider the impact of COVID-19 on its customers and products and implement measures accordingly. Consideration should also be given to whether the current control environment is appropriate and within risk appetite. Now, of course, the well-being of the firm's employees is paramount. As a starting point, firms would have considered health and safety checks. However, the general well-being of staff can often be overlooked. Regular check-ins with all employees by team leaders using video conference where possible, provision of counselling advice and working groups for absences due to childcare or carer commitments are also highly encouraged. It's important that firms continue to maintain a focus on culture. SMS holders should keep it in mind that many employees will find themselves under significant pressure in the coming days and weeks, balancing their workload in an abnormal and unprecedented way for extended periods of time. Regular reminders of the firm's values and standards of professional behaviour can be key in motivating and energising individuals. Example setting from senior management will be more important than ever. I also wanted to cover off what we're seeing and hearing in terms of the practicalities of operating effective corporate governance during this time. In times like this, the need for clear and decisive leadership based on reliable information is more crucial than ever. Meanwhile, disruption to working practices makes this harder than ever. The buck stops with the board. We all know that an effective board defines the company's purpose and then sets a strategy to deliver it. This purpose is still relevant in the time of a crisis. While management teams run companies on a day-to-day basis, boards are ultimately responsible. So the starting point for boards in this crisis, just as in any other crisis, is to direct the company in a way that is effective for all key stakeholders. Transparency and effective communication has become even more important during the time of crisis. Board members need to ensure that they have access to all relevant information. Based on our conversations with SMS clients and through what we know that FCA and PRA are asking of firms, we thought it might be helpful to set out some of the key questions SMS should be able to both answer and evidence. So, for example, what work has been done to consider how consumers have been impacted by the COVID-19 outbreak in the context of individual businesses? How is C19 impacting the products which you offer consumers? What additional measures have you or the firm put in place to support effective consumers, including the vulnerable, and how did you make these decisions? What work has been undertaken to assess the impact of C19 on your firm's finances and capital position? What succession planning is in place to cover any key absences, especially for SMS? What communication plans have you put in place, and how are you ensuring that these are clear? Are you comfortable that the control framework in place is within tolerance? How are you monitoring changes? What work have you done to assess the ongoing financial and operational resilience of third-party providers? Are there any regulatory requirements that are difficult to comply with given the current environment? And how has this been discussed at a board level? What decisions have been taken, for example? In times of crisis, the quality of the relationship between the board and executive management is critical. This is not a time for confusion as to who does what. Whilst methodologies and process may need to change as a consequence of COVID-19, the outcomes that the regulators expect have certainly not. Just moving on to the next slide, I wanted to focus for a moment on the key differences between solo and dual regulated firms. And in doing so, I mean in respect of evidencing reasonable steps. So overall, the underlying principle taking for both solo and dual regulated firms is broadly similar. However, we did want to outline the key differences on SMCR expectations between the joint statement for dual regulated firms and the FCA's statement for solo regulated firms. I think this slide nicely summarises that. We encourage the board to carefully consider and review as part of their firm's coronavirus response in consultation with HR and compliance, the possible reallocation of senior management functions and of prescribed responsibilities, temporary arrangements for absence or furloughed staff, and notifications which should be made to the regulator. Change is inevitable in the face of disruption, so the key priority for boards must be to ensure plans are in place to maintain effective governance and be able to demonstrate that it's working effectively. Both the PRA and FCA have stressed the importance of continued strong governance through this crisis. It follows that firms are going to have to make a number of tough and key decisions in the coming months. being able to evidence how and why these decisions have been made is more critical than ever. So that's the end of the material. So as I said, we had about half an hour that we wanted to cover off. So we're just approaching 10 o'clock now. That gives us plenty of time for questions and answers. So if you do have any questions, and I can see some have already popped up in the box, then do keep them coming in. We will obviously go through the ones that we've already got now. It's probably fair to say that the environment we're in at the moment is evolving at a fast pace. So some of the answers we may give will be based on what we're seeing and interpreting, opposing to actual regulatory facts at the moment. I'm sure you'll appreciate that. So I don't know, Shrenik, are you back on the line now?
Yeah, hi all, can you hear me?
Yeah, that's good, thank you. So Shrenik, hopefully you've been able to sort of prep for some of the questions that have been coming in. I don't know if there's any that you want to deal with now.
Yeah, sure. And apologies all that my line cut off earlier. There was one question I did see come through from David Jones on the list of questions that the list of specific dual regulated senior management functions must have for individuals performing the combination of senior management functions as a minimum. So I'll just repeat those. So is the CEO, SMS1, CFO, SMS2, and chair of the governing body, SMS9. The other combination was the head of the overseas branch, small insurer, senior management function, SMS25, that's for small non-solvency 2 insurers, and head of small runoff firms, SMS26. So those are the minimum combinations of SMS for dual regulated firms. What we will do is we will share this list with you all following the webinar. There was also a couple of questions I wanted to pick up that we had received prior to the webinar, but please do, that might be of interest, but please do share any questions that you have in the Q&A chat. So there are a couple of questions that we have from Robert Dickinson. Thanks for your questions, Robert. One of them was around on the senior management function point, wouldn't the regulator focus fall to the individual with prescribed responsibility for correct implementation of the regime? So those are specifically on prescribed responsibilities A and B. And I think the answer that we have to that one is yes and no. The individual which is allocated the prescribed responsibility for correct implementation of the regime, often the CEO, may receive a heightened focus. However, it is important to reiterate the point that the PRA and FCA have categorically stated that a single senior manager should not be solely responsible for the firm's coronavirus response. The onus is on all SMF holders and individuals which have been allocated prescribed responsibilities to ensure that those responsibilities are fulfilled to the extent that they can be during this time. Another question that we received from David was in relation to the firms that the BDO are currently working with. Have any of those organizations seen any increased instances of GDPR issues, specifically relating to emerging risks coming from home working or the pace of change to decision making? And I think that's an absolutely fair and valid question. Many of our clients have mentioned that the new working environment has brought about a number of challenges, including instances of GDPR issues, as you've mentioned, particularly in the earlier days, where some firms were not as prepared for a scenario like this. Many video conferencing facilities and tools such as Zoom have been used not necessarily in line with protocol, and clearer direction and guidance from the CIO or equivalent in relation to applications should be used for business purposes versus personal uses. Highly encouraged. I see we've got a question from David here as well. So in relation to furloughing of staff, a question was posed in that furloughing an senior manager who retains the senior management function does not make sense because a furloughed employee cannot work for the firm in any capacity. Therefore, how can they continue to be responsible for senior manager functions when they're out of the loop completely? So apologies, that question was from Frank. And I completely understand your question here, Frank, and also where you're coming from on this. To clarify, the furloughed senior manager will not retain the accountability and responsibility for that particular senior management function. That will shift to the SMF that has temporarily taken over responsibility for that function. However, what will be maintained with that furloughed staff is that they will maintain their regulatory approval unless they are permanently leaving their role.
Yeah, I think just to add to that one, Shrenik, I think that's right. So I think, technically speaking, the furloughed SMF, is still going to be on the books of the FCA or the PRA, if you like. I think, in practice, it's difficult to see how they're actually going to be able to hold that furloughed member of staff, responsible for the period in which they're clearly not at work. And, as Frank points out, it's clear from the government guidance that if you are furloughed, then you can't be involved in the business in any capacity. I suppose, the additional point I'd make there, which hopefully was clear from the material that we went through, is that the regulator is seeing the furloughing of SMS as an absolute last resort and should be avoided if possible. However, they're not completely ruling it out. And our expectation is absolutely that it would be very difficult for the regulator to then come after a specific individual SMS during a period that they were furloughed. I think what they would expect to see, and again, I think we touched on this briefly, is that both the person going in to take on those responsibilities, be they an existing SMF or not, have gone through a proper handover, etc., and are getting proper access to the right sort of governance forum so that they can actively and properly and appropriately carry out the role. And I think the firm then, I suppose, and all the other SMS have a collective responsibility to be able to demonstrate that that's happening. But I mean, the bottom line is this is slightly sort of uncharted territory, obviously, but you'd hope that pragmatism will prevail. And if nothing else, I think what this really does underline is the key point that we've been trying to make around when you are making any decisions like this, you are able to evidence through the governance framework that you have how and why those decisions have been made, and where there are potential risks arising from those decisions, what you're doing to try and take reasonable steps to mitigate those issues and risks. Shrenik, did you have any others?
There's one more I think that we actually had from a previous session that I think it's worth flagging and raising to all. The question was, will non-senior management functions holders who have prescribed responsibilities allocated to them in the absence of SMF have the same statutory personal accountability? I think it's a very good question. And I think our view really here is that it's not clear at this stage what personal recourse there will be to non-senior management function holders. And there is, of course, a potential risk that these individuals do not carry out their roles to the expected standards. Now, you can imagine there would be a couple of senior management function holders who are not approved carrying out or undertaking prescribed responsibilities that have been allocated to them. But we anticipate that other senior management function holders will support such individuals to help them ensure that they're able to demonstrate the reasonable steps they're taking to fulfill the responsibilities. And as Richard pointed out, particularly when he was talking about this piece on demonstrating and evidencing reasonable steps, this clearly would include having access to the right governance forums and management information.
Okay. Thanks, Shrenik. So I think that's all the questions that we've seen. If anyone has any others that they want to ask us offline, then happy to do that. So either email myself or Shrenik, and we're very happy to get back to you. There's been a number of sort of comments around the slides. So obviously we will circulate them, as I mentioned. And I think there's been a few questions around some of the detail that we went into, in particular, that list of sort of questions that I went through around what SMS should be asking themselves, if we can share that. So yeah, I'm happy to. So I'll pop those either onto a slide or a Word document or something, and we'll make sure that they get circulated as well. So I suppose that the final thing to say is thanks again for your attendance and participation. We hope that you found it useful. So do provide us with feedback. I think when you get the email after the event, there's a survey that we'd be grateful if you could complete. I think we're working on how we do these webinars, and we have a program of them scheduled over the next few weeks. So anything that we can do to tweak or change how effective they are, we're very happy to listen to ideas on that. And just before I do finish up, there's just a couple of things I wanted to mention around some of those additional webinars. So we have for the banks amongst the audience today, there is a session tomorrow on COVID-19 and in particular the impact of IFRS 9 on that. And I think we've already got quite a few people registered, but just wanted to mention that one's happening. And again, these will all be in the email that comes around later. Then on the 22nd of April, we've got that same sort of accounting update session to all other FS subsectors. On the 23rd of April, we're planning on doing a specific webinar focusing on conduct risk. Again, we touched on that in the webinar last week and the sorts of things that we're seeing firms thinking about. And we're going to sort of deep dive in a couple of areas there, in particular, the issue of arrears handling, forbearance and payment holidays, which obviously will be relevant to the lenders amongst you. We know that that's an area where operationally firms are being challenged, and we have some really useful insight there from work that we're doing with a couple of quite large lenders, which we're very happy to share. And then also we're provisionally scheduling a session on the 28th of April where we're focused specifically on the insurance sector. So some of that will be from a broader governance perspective and what that means for insurers, but also I think we'll take time there to focus on some of the conduct issues relating to insurers. So, that's likely to focus very much on claims handling. So that's all I wanted to say. Thanks very much again. And hopefully we'll see some of you soon at future webinars. Thank you.